the governor's absence will orchestrate a lacuna, that too is addressed by Justice Ngugi, where she considered Section 32, subsection 2 of the County Government Act, in which she observes that the governor, if the governor is unable to act, his functions can be performed by the deputy governor. Barring the first accused from going back to the office, therefore, does not violate the Constitution or amount to removal. It is intended to ensure the integrity and credibility of the trial and to ensure that public interest is safeguarded. Indeed, the judge in anti-corruption case number 25 of 2019 captured this concern more aptly when she remarked, and I quote, "He is charged with basically enriching himself at the expense of the people who elected him and who he is expected to serve. Would it serve the public interest for him to go back to the office and preside over finances of the county that he has been charged with embezzling from? What message does this send to the citizen of their leader when their leader, if their leaders are charged with serious corruption offenses and are in office the following day overseeing the affairs of the institution?"
So that is Anti-Corruption Court Magistrate Lawrence Mugambi. This is the big story, and welcome. So this evening we're focusing on Kiambu Governor Ferdinand Waititu. He was today freed on a 15 million shilling cash bail or a bond of 30 million and barred from accessing his office for the entire duration of his anti-corruption case. The Anti-Corruption Court Magistrate has also ordered him to surrender his passport and ensure he does not come in contact with any of the witnesses linked to this particular case. So that is what happened today. So there's a precedent to this, all of this. So on July 24th, Justice Mombasa Road ruled that governors charged with economic crimes should vacate office for the duration of their trial, and does not bode well for Kiambu Governor Ferdinand Waititu when you look at that ruling by Justice Mombasa Road. So in the ruling, Ngugi held that governors, like other civil servants, should step aside once charged for a criminal offense and their roles completely taken over by their deputies for the duration of the trial. That is where the interpretation starts differing from different lawyers from different angles, and that is one of the issues we'll be talking about. So she also termed Section 62, subsection 6 of the Anti-Corruption and Economic Crimes Act protecting state officers from stepping aside from office while under prosecution for criminal charges unconstitutional. So where does this leave Kiambu Governor Ferdinand Waititu? Let me bring in our lead reporter, Sophia Anuna, who's joining us from the city center. Sophia, good evening. There's been different interpretations of this. There are those who say the Kiambu governor is still governor. There are those who say, no, the deputy governor should take over. As a matter of fact, he held a press briefing today in the evening, and he said they will not allow a vacuum in the county of Kiambu. But then looking at the whole scenario, I did mention the governor still remains governor. So the question is, what sort of functions can he still perform? Where does that leave the deputy governor? And essentially, what does this all mean for governors in the entire country? I remember a couple of lawyers tweeting and saying this just opens a Pandora's box. Sophia.
Good evening, Linda. Indeed, many interpretations that we have had so far from various lawyers around what exactly this means, what it portends going forward. And in fact, that ruling you talked about by Justice Mombasa Road is one that's already been contested by the Samburu governor, who as well was barred from accessing his office over the charges that he's facing as well, corruption-related allegations of gross misconduct as well. So as to what this means going forward, let's get the views of Elisha Ongoya. He is a lawyer. He's also a law lecturer, I beg your pardon. Thank you for making time for us. Let's begin with some of the debates we've had, one of them being that he has been barred from accessing the county offices. And some argue, is it just the optics of that now he cannot go to that office, but if in a hotel or in another private office with members of his government, they can actually meet and transact county business. What does it mean to you?
Let's understand the law governing what has transpired today. There are three distinct processes in law that analysts are considering, are sometimes looking at as if they are one and the same concept. Neither Governor Waititu nor Governor Nkulala have been removed from office. They still remain governors as a matter of functional discharge of the office of governor.
Right.
They have also not been suspended from office, because that's a legal term that has a specific meaning attached to it. What has happened here is that bond terms have been attached. They have been granted bond by a trial court, and there are conditions attached to that bond. One of the conditions is barring them from physically accessing office and contacting witnesses. So in terms of the bar from accessing office, it's a physical bar. They should not be seen near the office. The concept of removal from office is different. It's not a physical process. It is a technical legal process that has functional consequences.
Right.
The concept of suspension from office is also not a physical process. It's a technical functional process.
Right.
None of those two has taken place. What has taken place is a physical bar by way of a bail condition. Now let our viewers understand this. When one is charged with a criminal offense, a bond question arises, and the court must determine one of two things. The first thing is whether there are compelling reasons to deny that person bond. If the court were to make a finding that there are compelling reasons to deny that person bond, it means that person must go in remand. That person will be detained in a prison or police facility physically, and therefore will not enjoy his liberty.
Right.
If that were to happen, and assuming that person were a governor, that person would physically not attend his office.
Right.
The second is where there are no compelling reasons, in which case the court has to release the person on bond. But when the court releases somebody on bond, the court gives the terms of bond. In this case, one of the terms of bond is that the governor will not physically access office and will not communicate with
witnesses.
Any of the witnesses.
So let me pick up on that point, contacting any of the witnesses, some of them being people, of course, he works with in the county government. So where is the line drawn between interacting at an official capacity with these officials and as far as executing his mandate and their mandate is concerned, to interference of the matters that are before court? Remember, can that be drawn, the line?
The bond term is not that do not interfere. It's in fact do not contact.
Okay.
That can mean physical contact, or it can mean contact through any of the non-technological devices of communication.
Right.
The governor would be extremely reckless if, under the guise of anything, including discharge of official function, he established any form of contact with the witnesses, so long as that person is a witness. A witness in this case is somebody who would have recorded a statement with the police or any of the investigative agencies regarding any information touching on the charges the governor is facing. So long as there's such a person within the officialdom of Kiambu County in the case at hand, then the governor would be extremely reckless if he purported to have any form of contact with that person.
How then does he ensure, and the entire county government operations are not affected if some of these officials are critical to running or functions in the county?
For practical purposes, one, the governor must physically keep off the county offices because the order says as much. In terms of functional discharge, to the extent that the function in question does not involve any of the witnesses, any person who is a witness is a known term in law, the governor can engage with them. To the extent that any of those persons is a witness in this case, then the governor is better placed keeping off those people, in which case the governor has a principal assistant. The governor will discharge those functions through his principal assistant, who is the deputy governor. Who unto the governor, if one of the witnesses is the deputy governor, then it means he must keep off completely and allow the deputy governor to discharge his functions. Now, this is not a very unanticipated experience. Our constitutional architecture and design worked on the assumption that we should get men and women of integrity into office. And if you listened or read the ruling of Mumbi Ngugi on Lenol Kulal's revisionary application, that is exactly the point that she was making. That once your integrity is in question, then you are not technically the kind of person our constitution anticipated to be discharging the function of that office, in which case your failure to discharge the functions of that office, even under the bond terms, is actually in accordance with the constitutional expectations that you will keep off until your integrity is reaffirmed.
There are those who see the governor's situation now as being one that presents the deputy governor an opportunity to perhaps play more roles. They have had issues there in the public domain as far as running of affairs in that county. So does the deputy governor stand as a benefactor, not only also in this case, but also in Samburu, that they can now come and run county affairs because of these orders?
Whatever the political consequences, the deputy governor remains deputy governor. He continues discharging the office of deputy governor as the principal assistant to the governor, and in the absence of the governor, the person who discharges the functions of office of governor, and if the governor is removed from office, the person who assumes the office of governor. I have said and I repeat, in this case, the governor has not been removed from office, in which case the deputy governor will continue discharging his functions as deputy governor, as the principal assistant to the governor in question.
Right.
In this case, the order in question will once in a while keep the governor out of office, in which case the deputy governor will discharge the functions of governor as ordinarily expected of any deputy governor in those circumstances.
Yes, but you say outside of office, but he could still work from elsewhere. That is the governor.
Yes, to the extent that that discharge of function does not lead him to physically accessing the office or contacting any witness.
Right.
The line is very thin. The governor must walk it very well advised that crossing that line can have disastrous consequences.
It's a tightrope.
Yes.
And Justice Mumbi Goge talked about Section 62(6) that leaves out constitutional officers from suspension and what many like to call stepping aside. She talked about this procedure for removal that's provided for, how to impeach a governor, a president, and other constitutional office holders. But in her view, she says this violates the letter and the spirit of the Constitution, that it does not pretty much add up. Do you agree?
I think Justice Mumbi Ngugi's remarks on Section 62(6) was what you call a by-the-way remark, because what was before her, if you look at what was before her, was a revisionary application where the governor was contending that the order barring him from physically accessing the office in effect was a suspension. In the course of her reasoning, she made observations that such a section that bars certain public officers from suspension and allows others to be suspended may be discriminatory. But I say it was a by-the-way remark, because that was the issue before her. The issue before her was the question whether that order, in effect, was unlawful. She made a find that the order barring them from office was lawful. But remember, there had been no decision made to suspend, because I've said a suspension is a technical process known to law, and there has been no suspension. The order that was before her, that was under her consideration, was whether physically barring him from accessing office and barring him from contacting witnesses is...
But do you agree there's a contradiction?
There is no contradiction whatsoever. And I think it's important that Kenyans understand how we interpret constitutions. The Constitution is not an ordinary document to be interpreted in terms of rules ordinarily applicable to interpreting other documents. The Constitution is a document like no other, to be interpreted in terms of its unique character. Now, how do you go about this? We say the Constitution must be interpreted in a manner that enables us to achieve its purpose. What are the purposes of the Constitution? One of the purposes of the Constitution is that public office is a public trust that can only be held in a manner that does not compromise the public trust in that office. And therefore, to the extent that, as to use the words of Justice Mumbi Ngugi, that there were people whose ethical hygiene was in question, are being told now, don't physically access the office, that is not far removed from the purposes of the Constitution. The Constitution anticipates that people who have confirmed ethical hygiene continue occupying office. So I don't think she was far off from the purposes of the Constitution in her interpretation.
Final question. The members of the County Assembly in Kiambu have already fired a salvo saying 30 days for the governor to resign, failure to which they will initiate impeachment process. Do you see, because there are those who argue, but he continues to be innocent until proven guilty, that's the principle in law, But the threshold when it comes to politics and the county assembly and all they'll be considering is different, isn't it?
It's very different. Impeachment is a political process underpinned by legal procedural safeguards. The grounds for impeachment, among other things, is where there are serious grounds to believe that the person holding the office of governor has committed a crime under national legislation. There are reasons to believe, not that he has been convicted. So in this case, by virtue of a decision of an independent office, the ODPP, to open a charge against the governor, there is therefore reason to believe. And therefore that ground, one may argue, has been met. But there are procedural safeguards.
Yes.
The county assembly must be careful to meet the procedural safeguards if it has to remove the governor. If it does not comply with those safeguards, just as it happened in the Wambora cases, the governor can challenge that impeachment. So there are two things. One, the grounds for impeachment, where there are reasons to believe a crime has been committed by the person of governor under national legislation. That is a ground for removal.
Yeah.
But more critically, there are procedural safeguards which you must comply with. Give him notice, give him audience, give him the requisite number of days that the law requires, which must be given to prepare his defense, give him a hearing, submit your resolution to the Senate for consideration. The Senate must approve it under the thresholds required by law before he can be removed.
Yeah.
Unless you comply with that procedure, then that decision is self-challengeable before a court of law.
And briefly, I know I said finally, but to those who argue that there's a conflict in the ruling and decision where the president and now deputy president were allowed to continue vying for office at the time whilst facing charges of crimes against humanity, and now this, do you see that conflict, that this confuses those who say this principle needs to apply both ways, of innocent until proven guilty?
I understand where the confusion is coming from, but you must remember that in the case of the president, the deputy president, in principle, the court held it had no jurisdiction to entertain the matter. And therefore, as a matter of law, the court ought to have downed its tools there. Whatever it said was neither here nor there. It held it had no jurisdiction. It said the question about assumption of the office of presidency was a matter within the jurisdiction or ambit of the Supreme Court or the IEBC in clearing. So the court downed its tools. In this case, we are dealing with a person who a decision has been made to charge him. There are existing grounds to believe that he has violated criminal law of this country, and therefore, yes, there is no contradiction in substance as far as I'm concerned.
All right. Thank you very much. Elisha Ongoya with us here on The Big Story, an advocate and law lecturer, giving his views on how this matter is unfolding and some of those issues. We've seen illicit great debate around the country and also in the legal fraternity. Linda, back to you.
Yeah, that legal fraternity, Sophia, is divided over this as well. But thank you for speaking to Elisha Ongoya, who's a lawyer. And we're looking at the fate of Kiambu Governor Ferdinand Waititu, who's been barred from accessing his office. So what exactly does that mean? So we had a presser today in the evening from James Nyoro, who's the Kiambu Deputy Governor. Could you listen in to what he had to say?
We are in office for as long as the governor is away. If there is going to be appeal, if there is going to be a ruling on his case, we will be ready to vacate the seat and leave it to the governor if the court so dictates. So we are here to ensure that the county continues. So this is not a coup d'etat.
This is not a coup d'etat. We are here to ensure the county continues. But then there's a problem as well. An acting deputy governor cannot perform certain functions, which we'll get to. But let's have this conversation this evening with Danstan Omari, who's a lawyer. He's joining us from our City Center studio. Danstan, thank you for your time. We're also speaking to Alex Manyasi, who's a governance expert. He's joining us from our Mombasa Road studio. Sir, thank you for your time. Omari, let me begin with you. So, Deputy Governor says this is not a coup d'etat. When he comes back, we'll hand this back to him. But then looking at that ruling by Justice Mumbi, there are those who say it is a little bit vague and it has opened a Pandora's box, quote unquote.
Fiasco in terms of the law, because I think the interpretation of Justice Mumbi's decision has totally got everybody off guard. There is no vacancy for the governor's position of Kiambu. What is only there is a physical barment. He cannot physically access the office. There are only three ways the office of the governor of Kiambu can fall vacant. One, by resigning he has not resigned. 2, by death, he has not died. 3, through impeachment. What has been provided is the ground for the MCAs to start an impeachment motion. So when I see the deputy governor saying that he is in office until when the governor comes in, is he going to be sworn in? Is he going to take an oath of office? Is he going to be delegated powers by Waititu? Therefore, there is a very wrong notion that people will need to be taught that the law is very clear. The process of removal of a governor is a political process, or through a death process, or through a resignation process. So therefore, what Nyoro is talking about is politics.
So we're in agreement, A, let's put the deputy governor aside and specifically deal with the governor for now. So what you're saying is Governor Waititu still remains governor as it is.
Governor Waititu, there's a contradiction Kenyans need to understand. Governor Waititu holds 2 roles. One, he's an elected person. He came to the office through the people's will. He represents them as a representative. 2, he occupies the executive position of a governor. And that is why the position of removal of a governor is through the people's representative, called the MCAs and the senators. It cannot be through the court process. People who are elected, their processes of recalling them, if it is members of parliament, there is a process of impeachment, and that is the only legal political mechanism available, not any other mechanism. A pronouncement from a court of law can only be a condition in terms of to comply with the bond terms. Therefore, Governor Waititu is the governor unless otherwise he resigns.
But then surely, Dunstan, what is the purpose of barring him from office? Because I was looking through social media, just comments, and Ahmed Nasir Abdullahi, Senior Counsel, says it's the person of Babayao that was elected governor of Kiambu, not the office in Kiambu. The address of the governor can always be changed, just don't interfere with the... Okay, can always be changed. So basically says, fine, you can tell the governor not to access his office. By tomorrow, he'll have a different office adjacent to the office and still go on with his work. So what is the purpose of all this?
I don't think that the judge understood the politics of this nation, and the judge must have gotten it totally wrong, because the governor is the person, is a body. He works with the power of being a governor anywhere. He sits in a hotel taking tea, he's a governor. He sits at KTN News doing an interview, he's a governor. The president walks all over with his powers. It's not the building, it's not State House, it's not the office of the governor. The physical presence of a governor is the powers conferred to him by that oath he took. We've seen in Nairobi, the governor in Nairobi has been transacting business from Mua in Machakos County. It does not need the physical presence. And therefore, this is only a ground for the political process to start. And this might be a very fundamental shift, because what my senior Ahmed Nasir is saying is that the executive now that controls the DPP and the DCI can decide to charge the 47 governors today and their deputies today. What will happen? It will be a political absurdity.
Okay. So, Dunstan, what you're saying is Governor Ferdinand Waititu, still the governor with full powers, can perform all functions. The only difference is he cannot get to his office.
That, according to the law, he has not been removed from office. If anybody has removed him, let us see who is going to swear in Nyoro to take off the powers. You cannot discharge the powers of the position of a governor unless, one, that power has been delegated by Babayao. Nyoro can only be delegated powers. 2, Nyoro can only be sworn in when the governor's position has fallen vacant. That position has not come to be there.
Okay. Okay, this is confusing a lot of people. Alex Manyasi, governance expert, thank you for staying with me. So give me your assessment of this whole scenario. You have a governor who's told you cannot access your office, but then Dunstan Omari says he still has the full powers of a governor. I mean, when you look at this vis-a-vis the war on corruption, what does this say essentially? I mean, he still has full access to his office. Okay, he may not have access to his office, but he still can carry out all the functions that a governor can. He still has all the powers. He can run his business from a different office. Okay.
Yeah, thank you, Linda. So if you look at, and the lawyers have already spoken, anybody who is making arguments around the governor having left office is being extremely pedestrian in the way they think about what the holder of the office means. If you look at, I also didn't know that Nyoro can be extremely ignorant about what it means when we talk about removing a governor from the office. Like the two lawyers have already spoken, Waititu is still governor of Kiambu. And in my view, to say the least, what the judges have been saying or have been doing, in my view, when it comes to trying to imagine that they can make a governor dysfunctional by the statements they have made around not physically accessing the offices, is also being emotional instead of being legal. And this is what I mean. When you say that a governor will not access their office, that has been done before. Obado was barred from accessing office. The governor of Busia was also barred from accessing office. And that has not stopped them from being governors. The governor of Nairobi, Mike Sonko, there's a time he was holding his cabinet meetings from his house in Machakos. So the office is neither here nor there. You can actually discharge your functions for your entire 5 years without having to step in your office. So for anyone to tell you that you need not access your office, it's just a statement that is neither here nor there as far as I'm concerned. One of the problems that probably the judiciary is grappling with is trying to make play to the public gallery by imagining that they make pronouncements which will make Kenyans be happier or think that the judiciary is making any step in terms of ensuring that there's a fight against corruption. What is going on right now is that there are two offices in this country, and that is the office of the governor and the office of the president. Those two offices have executive power, and therefore the drafters of our constitution and our laws forgot that the office of the governor is a mini office of the president. And therefore, the only way, when it comes to removing a governor, for example, and Omari has already alluded to it, is the backstops with the people of Kiambu. And they can only exercise that power through the representatives who are the county assembly members. And so unless that process is followed, or, of course, if the governor dies or resigns, and so Justice Mumbi was only hoping, for example, that the governor would resign. So if the governor resigned, and therefore that will have made it very easy for the people of Kiambu to get another governor. But as long as that has not happened, Babayao is still the governor of Kiambu. He will, if the case takes 3 or 4 years, he will still be the governor for the next 4 years, and therefore we will come to 2022 when Waititu is the governor of Kiambu.
And that is why the different interpretations are concerned, because I did mention today in the evening the deputy governor called for a press briefing in which he said there will be no room for a vacuum in county leadership. Omari, at the beginning of this conversation, you began by saying the deputy governor remains the deputy governor. I mean, who is going to swear him in? At the end of the day, Ferdinand Waititu still remains the governor, but even in his acting position, if I may say, there are functions that he cannot perform, can he?
There are functions, for example, he cannot sign the appropriation bill that allows the Kiambu government to spend money. Once the bill leaves the county assembly, it must be signed by the governor, unless under strict written instructions for the deputy to sign it. So that cannot be done by Babayao. 2, he cannot fire a sitting cabinet secretary, the chief secretaries. That is the preserve of the governor. And therefore, there is a question of the functionality of the exercise of the executive power. Nyoro is ambitious. He needs to get counsel, and I'm sure they are watching now, KTN Live, that what they are talking is to justify and cool the emotions or raise the emotions of the people of Kiambu. The law is very clear. And what the judge said, the judge looked at section 62. The judge never dealt with the articles in the Constitution that provides the tenure and security of the governor. She could not have challenged, because you cannot amend a constitutional provision through an application for revision for bail. It is bad. Kenyans want blood, but the blood cannot be given. We must follow due process. We chose the constitutional way to deal with it. Everybody is mad with the Babayao, but Babayao is insulated by the same Wanjiko who passed the constitution on the 27th of August 2010. So in my own view, this is a game of political chasing the wind. The governor still remains in office.
The governor still remains in office. The deputy governor still remains the deputy governor. You're watching The Big Story. We're trying to break this down for you. Thank you for staying with us. Let's take a short break. We'll be back in a few minutes.